in this series of webinars on MDAs as part of the IMAP MDA 360 program. I'm glad you could join us today. Yesterday we had a fascinating session on PI insurance. And I use the word fascinating because somebody that was speaking to this morning who watched the webinar said, I didn't think I'd find it as interesting as it was. It made me think. So that's the way we've tried to frame this series, things that make you think about the service that we offer. The MDA 360 program is this week of webinars. Today on understanding fiduciary duty, tomorrow conflicts of interest, Thursday fee disclosure, and then Friday a sort of summary session on sort of strategic considerations broadly about operating or advising on an MDA program. Then 3 masterclasses, in-person full-day sessions in October on best practice advice for MDAs. In November, a responsible manager masterclass preceding the MDA summit that I'll talk about in just a moment. And in December, the risk management frameworks workshop, how to set up and establish a risk management framework for an MDA program. In part, this has been driven by the fact that ASIC is reissuing the instrument because each 10 years they're required to do that. It's an instrument, not law. And they've told us at IMAP that reissue will be in September for a go-live date on the 1st of October. So a few weeks after that reissue of the MDA instrument, we'll be hosting a 2-day conference, the MDA Leadership Summit here in Sydney. And we'll be reflecting on what the changes, if any, to the instrument means and whether it's now, that's behind us, let's get on with it, or whether it'll invite us to deeper considerations if the changes are substantial. This program's made possible by the support of leading consultants, lawyers, brokers, those who bring a real depth of expertise to this area. Today we're joined by Andrew Bradley, partner from HSF Kramer. And the program generally is made possible by the support of Mason Stevens, long-standing MDA provider. And it's now my pleasure to invite Nick Mitchell from Mason Stevens to say a few words. Nick, over to you.
Good on you, Toby. Thanks to you, mate, and thanks to everyone attending the session today. We're proud, as always, to partner with IMAP, especially for this webinar series to help the industry demystify the finer points of establishing and managing and advising clients under an MDA service. So, and very briefly, for those who aren't familiar, the Mason Stevens platform, we've really been at the forefront of MDAs for over 16 years. We're the only wealth platform in Australia with an integrated MDA offering. So we understand what it takes to deliver a really exceptional managed account experience at the portfolio manager level, right through to the end client. And that experience runs deep. So the majority of the funds on our platform operate under an MDA, and that drives how we've developed our service prop and platform technology, which is really dedicated to ensuring that that service works really seamlessly for partners and their clients. So our DNA is investments and markets. So we really understand what it takes to what we call deliver exceptional investment outcomes. So whether that's utilising our live trading desk, assisting with governance and investment committee frameworks, occasionally provide IC representation or deliver analytics and reporting. We've built a really broad suite of services that enables our partners to deliver the best portfolio outcomes for their clients, particularly in the wholesale and high net worth space. That's enough from me. I'm really looking forward to hearing from Andrew. Please reach out if you'd like to chat about how we could assist. But for now, I'll hand it back to Toby to begin today's session. Thanks.
Great. Thanks very much, Nick. And before I hand over to Andrew to take us away, let me just say a few words about one of the other events that IMAP is hosting On the 16th of September, as part of Sydney Alts Week, we'll be organising a session in the afternoon on alternatives and discretionary portfolio management, following the family offices session as part of Sydney Alts Week. One of the things about MDAs, of course, is the capacity to accommodate, incorporate alternatives into portfolios. So if this is an area of interest to you, I'd encourage you to come along. But now it's my pleasure to hand over to Andrew Bradley, partner of Herbert Smith Freehills Kramer, to talk to us about fiduciary duties. Andrew, thanks very much.
Thanks, Toby, and it's a pleasure to be here. Great to meet everyone. As Toby mentioned, I'm a partner at Herbert Smith Freehills Kramer, which I appreciate is a mouthful. I lead the financial services practice, and I'm based in Sydney. So today we want to talk to you about the fiduciary duties that attach to both an MDA provider and an MDA advisor. If I just go to the next slide, thanks, Toby. I think managed discretionary accounts on the whole are a somewhat curious creature in the sense that, ostensibly they're a form of managed investment scheme that are subject to relief given by ASIC, and Toby talked about the MDA instrument and how we're expecting that to be revised with effect from the 1st of October. Now, there's a series of duties that are set out in the MDA instrument that you'd all be familiar with, and they're things that are required to be included in the MDA contract, and things like performing your duties and obligations honestly and with a degree of care, skill, and diligence that a reasonable person would exercise in the licensee's shoes, acting in the best interest of the client and performing duties in relation to the MDA service. And if there's a conflict between those interests and their own interest in performing those duties, giving priority to the interests of the client. Another one that's important to mention is the obligation to compensate clients for any loss arising because of any act or omission of any agent or other person engaged in connection with the MDA service, other than an omission of an external MDA custodian or external MDA advisor, or the person on behalf of either, or a person acting on behalf of either, as if the acts or omissions were the acts and omissions of the licensee. Now, again, I appreciate that is a mouthful, but what I really wanted to draw out there is this concept that you've got this obligation under the class order to compensate for loss. And what we'll see as we go through today's presentation is that actually your general law fiduciary duties can actually impose a more powerful set of obligations and can even require compensation that goes beyond the losses that a client might have suffered, and can even trigger where a client hasn't suffered a loss at all. So fiduciary duties, I would say, are not well understood. And as a result of that, there is that risk that fiduciary duties might be overlooked. It's very easy, I think, to look at these ASIC instruments and to think, well, that's a checklist of the duties that I need to be thinking about. And I just encourage you to think differently about that. And I hope that today, as Toby said, we get you thinking a little bit and understanding a bit more about how fiduciary duties might attach to the role of an MDA provider or an MDA advisor. Importantly, the best interest duty that we talked about, both the statutory duty that applies to financial advisors, as well as the duty that's imposed under the instrument, they are complementary but distinct to your fiduciary duties that arise under general law. And we'll talk a bit more about how those duties arise under general law and what the hallmarks are of a fiduciary relationship. I've talked a little bit about the remedy side of it. On the enforcement side, what we typically see, obviously, in our space is ASIC as the regulator looking to enforce compliance with the Corporations Act, compliance with the licensing regime. I think there's probably two things that I would draw out here. Firstly, and we're not here to talk about the MDA duties under the class or the instrument, but it's interesting to me that those duties are required to be imposed under the MDA contract, because the effect of that is that it's not actually ASIC that can enforce compliance with those duties, the best interest duty under the MDA contract. It's the client through the contract. ASIC could say that you're in breach of the instrument and can take various actions as a result of that. But in terms of actually breaching those specific duties, it's a contractual obligation owed to the client under the MDA contract. Similarly, when we come to fiduciary obligations, they are obligations owed to the client, and they're not things that you typically see ASIC pursuing. It's really more clients that can pursue claims, and clients can have the best of both worlds. They can pursue a claim under statute, they can pursue a claim under the MDA contract, they can also pursue a claim under their fiduciary fiduciary obligations of the providers as well. So if I just go to the next slide, what do I mean when I start using this term fiduciary? And I'm sorry if you thought you'd get away with listening to a lawyer without me mentioning Latin at some point in time. So we will get into that. But the word fiduciary derives from the Latin fiducia, meaning trust or confidence. Roman law recognized the fiduciary as a form of trust arrangement by which property was transferred to another on the basis of a relationship of confidence with an obligation to deal with it in a particular way. And whilst English equity law didn't transplant Roman law specifically, the underlying moral idea that a person entrusted with another's property must act in good faith is a common thread. So I've given you there on the slide sort of the simplest form of definition. I would say that a fiduciary is a person who's agreed, whether expressly or by the nature of their role, to act in the interests of another person, placing that person's interest above their own. The law imposes on a fiduciary a strict duty of loyalty. They must not allow their personal interests or duties to third parties to conflict with their duty to the person that they serve, and they must not profit from their position without authorization from the client. The relationship is characterized by trust, confidence, and the vulnerability of the person being served to the decisions of the fiduciary. And we'll go through some of the elements of a fiduciary in a moment. The key thing to understand here is that the fiduciary duty arises from the facts of the relationship, not merely from a contract or a job title. So you'll see at the bottom of the slide there that you can't contract out of fiduciary duties. Certainly, the scope of your duties will be informed by and can be limited by the terms of a contract, but substance will prevail over form. If we go through some examples, if you have been providing financial advice to someone for 25 years and they trust you deeply, and you get them to sign a piece of paper that says this is not a fiduciary relationship, that is highly unlikely to save you from being regarded as a fiduciary when you're providing that advice. Just go to the next slide, please. So let's talk about the elements of what constitutes a fiduciary relationship. Just to show you that the law isn't as the leading Australian authority on the hallmarks of a fiduciary relationship is actually a case called Hospital Products and United States Surgical Corporation. And the leading judgment on this is actually the dissenting judgment in the case. So just to give you a little bit of interest, I know Toby and I have chatted a bit about some of the cases that stick in people's mind. And I think Hospital Products is a good one to keep in mind. So United States Surgical Corporation manufactured surgical staplers. It had a representative, Alan Blackman, who became the exclusive Australian distributor for these surgical staplers. Instead of acting in the interests of Hospital Products and looking to distribute those staples, he tried to reverse engineer the products and set up his own rival company that effectively undercut the market and substituted United States Surgical Corporation's orders with his own clone products to try and capture the market. Now, ultimately, the court held in that case that the arrangement was a purely commercial arm's-length contract between self-interested corporations and that equity should not strain to impose a fiduciary duty of loyalty there. You see some of the words on the screen, you'll hear, again, we'll go through this, but you see things like the concept of undertaking to act as the beneficiary, the concept of vulnerability. In that case, ultimately, the court held that there wasn't an imbalance of power. This was two self-interested corporations going into a commercial deal and each acting in their own interests. Where a fiduciary duty will arise is where these five elements will arise. So where we've got the most important one is the undertaking. So the central hallmark of a fiduciary obligation articulated by Mason in the dissenting judgment is that a fiduciary is someone who's undertaken to act for and on behalf of another in circumstances that give rise to a relationship of trust and confidence. And we'll go through some other case law examples on this in a moment that are a bit more relevant to financial advisors. Now, that undertaking can be express or can be implied from the circumstances of the relationship. The second element on the slide there, vulnerability. So this is about whether the beneficiary is in a position where they're dependent upon the fiduciary to act in their interests and are unable to adequately protect themselves. So certainly the vulnerability element will be met in circumstances where there's a significant imbalance of power. And you see there at point 4, the inequality of bargaining power point, which is similar. But vulnerability can arise even between sophisticated corporations where one is dependent on the other and has limited means to protect themselves. And I would venture that where an MDA operator is providing a financial service of operating an MDA, and the client doesn't have visibility as to the discretionary decisions that are being made, the client will be vulnerable to the decisions of the MDA provider and unable to adequately protect themselves. The third element is that the relationship must be such that the beneficiary has a legitimate expectation that the fiduciary will act in the beneficiary's interests rather than in the fiduciary's own interests or in the interests of a third party. And this expectation of undivided loyalty is a defining feature of fiduciary relationships. Mentioned inequality, I think it ties in somewhat to the vulnerability point, so I won't belabor that. There must finally be that the fiduciary holds a power or discretion affecting the beneficiary's interests. So that power or discretion may be a legal power, it might be a practical power, but when exercised, it needs to affect the interest of the beneficiary. And it's that conferral power that justifies the imposition of the duty of loyalty. So the beneficiary effectively surrenders decision-making authority to the fiduciary. And you can hear in that language why I think that this attaches very much to the operations of an MDA. Let's go to the next slide. Thanks, Toby. So let's just think about the so what. So you're telling me that I've got this fiduciary duty. Well, what of it? Well, a fiduciary is subject to two core proscriptive duties, which are collectively referred to by lawyers as the duty of undivided loyalty. And the duty of undivided loyalty is effectively two duties because we like to be confusing. So firstly, the no conflict rule, and secondly, the no profit rule. So the no conflict rule says that a fiduciary must not place themselves in a position where their personal interests or their duties to another person conflict with their duty to the beneficiary without the beneficiary's informed consent. Now, this is important in that if you were to look at, your AFSL license and you look at the conditions on your AFSL, you'd be familiar with the concept of needing to manage conflicts of interest. Well, what a fiduciary's primary obligation to do is actually to avoid conflicts, to not put themselves in a position where their personal interests conflict with duties to beneficiaries. And where conflicts might be unavoidable, there is that ability to manage conflicts, but your primary duty is to avoid conflict in the first place. Secondly, the no profit rule. A fiduciary must not make an unauthorized profit from their fiduciary position. So the concept of fiduciary arose originally in the concept of trusts. And at law, a trustee is a volunteer unless the terms of the trust allow something different. So what does that mean? That means we need to have very clear and informed consent to any profits that you might make from your position. And that is not just fees, it's any profit that you might make from your position as a fiduciary. And again, I'll give you some practical examples there. You heard me use that term proscriptive. What do I mean by that? So proscriptive duties are prohibitive duties. They prohibit certain conduct rather than being prescriptive. They don't require you to do certain things. So must not put yourself in a position of conflict, must not make an unauthorized profit. That is different to, say, a duty to pursue the interests of a client. And in that sense, somewhat interesting sort of comparison to the best interest duty as it exists for advisors under 961B of the Corps Act or for MDA providers under the contract and under the instrument. The best interest duty is often thought of as somewhat prescriptive too, in the sense that it's not imposing positive obligations to go ahead and do things, but rather saying when you exercise a duty, you've got to put the client's interests ahead of your own. But then particularly in the context of an advisor, we've got the safe harbor rule. And the safe harbor rule then sets out a series of steps, which in a sense might be regarded as prescriptive, and you do these certain things and you meet the other duty. So I think that's, again, important to understand that your fiduciary obligations are proscriptive, they're prohibitive duties. Next slide, thanks. So I'll get a little bit into case law here, but I promise it'll be interesting and we won't get too heavy. So the seminal case on whether a financial advisor would be regarded as a fiduciary is Daly versus Sydney Stock Exchange. So Patrick Partners, a stockbroking firm, was an advisor to Dr. Daly and advised him against investing on the stock exchange and instead recommended that he lend his money to the broking firm. Daly accepted that advice and made the loan. The firm, of course, became insolvent. Dr. Daly lost his money. In that case, a fiduciary obligation was held to exist because Patrick Partners held itself out as an advisor on matters of investment. It undertook to advise Dr. Daly. You remember that key element of an undertaking. And Dr. Daly relied on the advice given to him by Patrick Partners. So if we think again back to our list of criteria, we had the undertaking to act for the beneficiary. We've got the vulnerability. We've got a legitimate expectation of loyalty. Dr. Daly expected Patrick Partners to be acting in his interest. There was an inequality of bargaining power, and the fiduciary held power of discretion affecting the beneficiary's interests. I think that last one is actually probably a little bit more curious, but fiduciary obligation was held to exist. Let's move to our next one. So CBA, Commonwealth Bank versus Smith. The Smiths were long-standing customers of the CBA. The branch manager, Mr. Dungan, encouraged them to buy a hotel lease from another bank customer, really with the ultimate aim of trying to secure repayment of a loan from that other customer for the bank, for the benefit of the bank. The manager advised the buyers that it was a good buy, downplayed the risks, and actively discouraged them from seeking independent accounting advice while hiding the true lower valuation and poor performance track record of the lease. Now, why is this case important? I think the reason this case is important is because ordinary banking would be regarded, in terms of day-to-day banking, would not be regarded as a fiduciary duty. It's a transactional service where the bank acts in its interests. If you were looking to take a loan from the bank doesn't owe you a fiduciary duty. It's looking after its own interests in trying to secure payment of the loan. However, in this case, the branch manager crossed the line in that he led the Smiths to believe that he would act in their interests in giving advice on the merits of the investment, discouraged them, in fact, from seeking independent advice, accredited that vulnerability. He, in a sense, became an investment advisor. And so align that with the Daly case above. He's holding himself out as someone who has expertise in this area. They are relying on his advice. They understood, in this case, that the bank would benefit. They understood that there was this loan that the bank was looking to get repaid on. And so the no profit rule wasn't violated. However, the bank breached the no conflict rule by advising the Smiths. And why do I say that? Because the bank put itself in a position of conflict by advising it all on this issue. Now, I keep saying the bank, but really, if you like, Mr. Dungan, as the branch manager, did those things, but the bank was held vicariously liable for the actions of its employee. Go to the next slide, please, Toby. Two more, and then I'm done with cases. I might mention a couple more. So the third case to mention is Aquitas and what we call AEFC, which was later renamed to Sparrow number 100. So Aquitas was hired to provide financial advisory and corporate structuring services to, AEFC was hired to provide those services to Aquitas. Aquitas was a property developer looking to set up a bunch of companies and invest in various properties, and AEFC structured those transactions. But in doing it, it did that to derive benefits for itself and failed to properly disclose those personal interests and profits. Aquitas got the benefit of the transactions and generated a profit from this arrangement. But a fiduciary obligation was held to exist because AEFC, again, held itself out as an expert on investment matters. It undertook to perform a dedicated financial advisory role, acting in the interests of Aquitas. The last case I wanted to mention is one where no fiduciary obligation was held, and that's an important one for advisors to understand too, and that's Pilmer and Duke Group. So this is a case where Duke Group retained an accounting firm, Nelson Wheeler, to provide an expert valuation of a proposed takeover target, Western United. Nelson Wheeler failed to discharge its duties. It overvalued the target and was found to breach the accountant's duty of care. In this case, the court held that no fiduciary obligation existed. Now, why? Nelson Wheeler was hired as an independent expert, not as an advisor hired to act in the interests of Duke Group. And so in providing that valuation, it was not intended that they try to provide a favorable valuation to make the deal go through or try to help Duke Group's interest. It was an independent valuation, and that's something that's quite separate and distinct from a fiduciary obligation. Now, why is that important for advisors? There is a distinction to be made between providing investment advice and providing sort of execution services, right? And so I might mention a couple of other cases. So a good example of this, there was a case, ASIC versus Citigroup in 2007. And in that case, Citigroup was held not to be a fiduciary in respect of its corporate advisory clients because it was acting as principal in trades rather than as an agent or a discretionary manager. So where you provide an execution service, that doesn't necessarily mean that a fiduciary obligation will exist. Again, it's the substance of the relationship. And I think that's really important to understand, is that a relationship is not necessarily fiduciary or non-fiduciary. A relationship can have elements of both. And so it can depend on the services that you're providing at a particular point in time as to whether a fiduciary obligation attaches to those services. Okay, I think that's enough heavy law. Let's go to the next slide. So again, if we've got these fiduciary duties, what does that mean? What is the problem with that? Well, the remedy for breach of, say, the statutory best interest duty is a compensatory remedy. It's directed at making good clients' losses, and that's what we typically see in the financial services industry. However, if you're found to be in breach of fiduciary duty, the remedies go beyond mere compensation to also deprive the fiduciary of gains that they improperly earned. And so examples of that can be that a client can obtain what's called an account of profits, which is tell me all of the unauthorized profits you've obtained through your position, and I can actually claim them for myself. It can even look for equity to impose a constructive trust over assets acquired by the fiduciary in breach of duty. So a client in that sense can recover under a breach of fiduciary duty, even if they've suffered no damage at all. I've given a bit of a self-serving example on the slide there. So I am in the moment in the process of opening up a whiskey distillery in Sydney. And so I've used that as an example. But let's say that I'm a financial advisor. I'm also the co-owner of this whiskey distillery, which will be named Cricketune Distillery. Let's just say that I don't mention that to my client. And so in this case study, my client, Jasper Jack Daniels, I encourage him to invest in the distillery. I don't mention that I actually am a co-owner of the distillery. The distillery goes gangbusters, does really, really well. Jasper gets a great return on his investment. However, he then learns that I'm a co-owner and I'm now standing to make, in this example, $100 million from the proposed sale of Cricketune. Wishful thinking on my part. Notwithstanding that in this example, Jasper hasn't suffered a loss, Jasper could seek to recover from me all of the profits that I made as a result of procuring the investment by Jasper. Now, that won't necessarily be all of the profit that I make from the venture, but it is the profit that I make as a result of the misuse of my position as a fiduciary. So you can see the significance of the potential consequences of a breach of fiduciary duty. Okay, we'll go to the next slide. So this is just a quick sort of ready reckoner on some of the differences between statutory and fiduciary duties, and you'll see those first few lines on the table cover what I just talked about in terms of under fiduciary duty, you can have an account of profits or potentially constructive trusts over assets. There's other forms of remedy mentioned on the page there, like rescission and injunctions. Rescission is effectively the cancelling of a transaction and pretending it never happened, which is something that equity can do. Generally not available for breach of a statutory duty, although there are some specific provisions in the Corporations Act that allow for rescission. Example would be where you haven't provided an FSG or where you engage in misleading and deceptive conduct. There's a couple of section numbers there where I've referenced those powers. But the two things I really wanted to draw out on the slide here are the two that are highlighted. And I think that this will be probably things that are key to take away. So firstly, whilst we think of our best interest duty as being a duty that applies to retail clients only, fiduciary duties attach just the same to wholesale clients as they do to retail clients. There is no distinction. Now, again, it comes down to the nature of the relationship and the nature of the services and the terms on which the services are provided, the relative bargaining power of the parties and so on. But there is no distinction at general law or at equity between a wholesale and a retail client for this purpose. So that's important to understand. The second thing that is probably most important to understand is that unlike the statutory best interest duty that attaches to advisors, there is no safe harbour defence for a fiduciary obligation. There's no checklist of things that I can do to say, well, if I do all these things, then I won't be in breach of my fiduciary obligations. So those are probably the two key takeaways on that slide. Thanks, Toby. Next slide. So let's do some myth busting. I think I've busted a few myths already, but we'll go through these. So I've talked a little bit about avoidance of conflicts, that first one there. So a primary duty at law of a fiduciary is to avoid conflicts. And that means if I know that I'm in a position of conflict, I should decline to act for the person in the first place. Now, there is the ability to get clients fully informed consent to certain types of conflicts and certain types of remuneration, but you heard in my language there, fully informed consent. So mere disclosure is not the same as consent. And equally, you'll see there that yellow box there, client consent will eliminate fiduciary liability. That, again, it's very difficult to exclude fiduciary obligations in their entirety. And generally, I think lawyers will never speak in absolutes, but it's pretty much impossible to completely eliminate fiduciary responsibility. You can certainly curtail it and manage it, but that consent needs to be fully informed consent. If you're looking to rely on disclaimers in the back of an SOA, then you're really on the back foot when it comes to mitigating your liability there. We had a slide on the differences between fiduciary duty and the statutory duties, but again, to blow that myth up, the fiduciary duties are not the same as the best interest duty. They are somewhat similar in that the best interest duty talks about putting the client's interests ahead of your own. Fiduciary duties talk about acting in the interest of the client and not in your own interests. So that in that sense, they're similar, but the consequences are different and the way that we manage them is somewhat different. We've talked about retail and wholesale. So fiduciary duties are not only owed to retail clients, they're owed to all clients, retail or wholesale. The grey one in the middle there, my duties to every retail client will always be the same. Well, you've heard me talk about how the nature of the relationship will depend on the factual circumstances. And so a fiduciary duty is not as simple as it's on-off. It will depend on the types of services that are provided. It will depend on the amount of reliance that's being provided. So it won't be the same client to client. Now, you might, in practical sense, manage things fairly uniformly, but the fact that you've got a duty to one client doesn't necessarily mean you've got a duty to another. It does depend very much on the services you're providing to each client and the nature of the relationship between you. Another big one is that the concept that fiduciary duties end when the advisor relationship ends, and I'll caution you against this one too. So if you've obtained information in the course of acting as a fiduciary and you use that information later on to derive a gain for yourself, well, again, the fiduciary can have the ability to account for those profits. So let's say, a client brings an investment opportunity to you and you go, that's all very interesting. You put it away in a drawer and then you cease to act for that client and you take advantage of that investment opportunity. It could well be, depending on the circumstances, that you've got a liability to that client for taking advantage of that opportunity and not presenting it to the client. I've talked about the suffering loss. A fiduciary duty can only be breached if the client suffers loss. I really hope no one ever picks up these slides and reads this page as if it's supposed to be a list of facts. It's all in the reverse, right? So a fiduciary duty can be breached even if the client makes an excellent profit. You saw my example of the distillery example. Client made a very good profit out of his investment, but the fiduciary made an even bigger profit, and the fiduciary could be liable to disgorge those profits and hand them over to the client. And finally, I want to mention that the concept of receiving a benefit is okay as long as it's not conflicted remuneration and it's disclosed. So we've all had conflicts and conflicted remuneration drilled into our heads since FOFA started, and we all understand what benefits and non-cash benefits can be regarded as conflicted and what falls outside of that. The fiduciary net is much broader than the conflicted remuneration net. If you're in a position where you generate a benefit for yourself or for a third party as a result of your position as a fiduciary, that is something that is potentially at risk if a breach of fiduciary obligation is found. So it is important to understand the scope of the duties for that reason. Go to the next slide, please. So I am whizzing through this in the context of an MDA provider or an MDA advisor. I think the question that often comes up is, well, okay, so what does this all mean for me in terms of managing dual roles, and particularly where I might be providing advice to a client recommending that they enter into an MDA. And then I've also got a related party that's providing the portfolio management services on the MDA. So this is a bit of a checklist, and I think it's all a little bit common sense, but the first thing would be to conduct a genuine and independent assessment of the product. So when you're maintaining your APLs, you've got to have a meaningful range of third-party options alongside related party products so that the advisor is genuinely comparing alternatives rather than selecting from a curated list of in-house products. Using objective research. So where possible, using objective research from independent research providers, assessing the product's features, fees, performance, and suitability relative to competitor offers. Documenting that comparative analysis. Won't surprise you to hear a lawyer talking about documenting things. Doing that, though, in a manner that demonstrates that the advisor has considered a range of alternatives and has selected the related party product because it genuinely best serves the client's interests and not because of institutional preferences. Ensuring that the advisor's assessment is not contaminated by internal training or materials that present a related party product in an unduly favourable light without reference to its weaknesses or any sort of competitor alternatives. So the key question in equity and in statute is essentially the same. Would the advisor have recommended this product if it were not a related party product? If the honest answer is no, the recommendation cannot be defended. So the second point is full, frank, and comprehensive disclosure. And you've heard me talk about disclosure and the difference between disclosure and consent, and the next point will be consent. But in order for disclosure to be comprehensive, it needs to be specific and precise and quantifiable. So it is not satisfactory to say we might receive benefits from third parties, for example. That's all very vague and will not get you to a position where you can say, I have not breached my no profit rule. We need to make sure that our correspondence is in plain language, that it's understandable by the client. We need to provide that disclosure in a timely manner. And whilst it's okay to provide that disclosure orally, obviously the best way to protect yourself is to make sure that you draw that to the client's attention verbally and also record that it's been done in terms of putting it in writing as well. The standard required in equity for informed consent is an exacting standard. A client who's been handed a standard FSG and is asked to sign it without having the conflict explained to them has not given the kind of informed consent that will protect the advisor from a fiduciary claim. So step 3, obtaining genuinely informed consent. Beyond just disclosure that we just talked about, advisors should obtain the client's genuine and informed consent to the recommendation of related party products in full knowledge of the conflict. That means explaining to the client in plain terms that the product being recommended is manufactured by a related party and that this creates a potential conflict of interest. Explaining how the advisor has managed that conflict, for example, by conducting independent comparative analysis. Giving the client a genuine opportunity to ask questions and seek alternative advice before proceeding. And then recording the client's consent in a manner that is contemporaneous, specific, and verifiable, ideally in writing, signed by the client. Consent that's obtained by presenting the related party product as the only or the obvious option, or in circumstances where the client feels they have no real choice, will generally not be regarded as genuine consent in the courts of equity. So documenting the advice process thoroughly, I'm sure, again, this is something that's very familiar to you all, but keeping a record is really critical. The file should contain things like a record of the client's relevant circumstances, their objective, their financial situation, their risk profile, their needs. It should contain a comparative product analysis showing why the related party product was assessed against genuine alternatives. It should show the reasons for the recommendation, articulating why the related party product best serves the client's interests in those specific circumstances. Should show evidence that adequate disclosure has been given, evidence of client consent, as we've talked about, and then also record any ongoing review of the product suitability that's going to occur over time. That sort of documentation will help you to withstand the scrutiny of ASIC, a court, or AFCA. In the context of fiduciary obligations, it's most likely to be clients or AFCA that you're looking to face into. And again, as you know, when it comes to AFCA, we're really just looking at whether decisions are fair and reasonable. And so again, documenting why that decision was fair and reasonable as part of that documentation of the advice process is really helpful in terms of mitigating AFCA risk. The The fifth step on the slide there, implementing robust conflict management protocols. Again, something I'm sure you've heard lots about over time. It's important that you have a conflicts of interest policy that specifically addresses related party products and sets out how the conflicts are identified, assessed, disclosed, and managed. You've got to have governance structures that ensure product recommendations are not driven by revenue targets or institutional pressure. For example, you might have a product governance committee that includes independent members. You've got to have remuneration structures that don't incentivize advisors to favor related party products. And again, you'll be needing that from a conflicted REM perspective as well. Examples of that would be avoiding advisor bonuses being tied to volume of related party product sales. It's an obvious one. You've got to have supervision and monitoring of advice to identify patterns of over-recommendation of related party products, training that equips advisors to understand and manage conflicts and that doesn't present related party products in an unduly favorable light, and whistleblower protections that allow advisors to raise concerns about institutional pressure or to recommend related party products without fear of reprisal. And then ongoing review and monitoring. So again, if related party products have been recommended, making sure that they're monitored on an ongoing basis to ensure they remain in the client's best interests. And where that sort of a related party product ceases to be competitive, perhaps because its fees have increased or its performance is not as good as hoped compared to alternatives, taking appropriate action, which might include recommending a switch to a competitive product, notwithstanding the institutional cost of doing so. Those are probably the key things to mention on that slide. Next one, Toby. I think we're done. Great. I'm happy to take some questions.
Right. Look, thank you very much, Andrew, for a comprehensive run through. And I'd encourage you, if you're listening, to submit questions. There are a number that have come through already, which we can start off with. But one of the things that struck me listening to your presentation, Andrew, is how relatively specific fiduciary obligations become. They are situationally dependent. And do you want to talk a little more about that issue of to expand a little more on that sort of the specifics of the relationship drive the nature of the fiduciary obligation?
Sure. So I think ultimately in the context of a vanilla advice relationship, you're very, very likely to be a fiduciary in the daily case that we talked about, where the stockbroker that was recommending that they invest into the stock, that Dr. Daly invest into the stockbroker, is the classic example of it. So again, the elements, you've got the undertaking to act on behalf of the client. You're going to have that invariably in an MDA structure. You've got that vulnerability, and that, so the vulnerability doesn't necessarily mean that the client is not sophisticated. It just means that the client is dependent upon you to deliver an outcome, and it doesn't necessarily have visibility of that outcome. And you've got that legitimate expectation of loyalty. So the terms of the MDA contract can somewhat modify that, but when we've got an MDA instrument that requires certain things to be put into the contract, like a duty to act in the best interest of the client, it's almost like it's overlaying a statutory form of fiduciary obligation. It's saying, well, you've got to act in the interest of the client, put the client's interest ahead of your own. That's almost creating the undertaking for you. So I can envisage a scenario potentially where you might be able to say, my fiduciary obligations are very limited, but I think in practice, you'd be safer off just assuming that a fiduciary obligation exists, even with the most sophisticated clients.
And this whole series is framed around MDAs, but of course, do these obligations exist in respect of SMAs as well, or would you typically expect them to exist in respect of an SMA?
Yeah, so the starting principle at law would be that all trustees are deemed to be fiduciaries, and SMAs are typically offered through a registered scheme. And so the registered scheme, you've got a responsible entity, and that responsible entity has statutory duties to act again in the best interests of investors, but also general law duties and fiduciary obligations. So there's absolutely a fiduciary obligation in that scenario. What I think is interesting is how far down the chain does that fiduciary obligation go? So if I'm operating an SMA, if I'm an institutional SMA that's then offered on a platform, technically the holder on record will be the custodian of the platform, not the underlying client. And does the fiduciary obligation trace through to the end client? And the answer to that is a little bit uncertain in the sense that we've not had specific case law on SMA structures, but I think it's highly likely that it would be seen to pierce through all the way to the end client. Now, again, I can imagine structures where the SMA provider would say, I don't even know who the end client is. How can I owe a duty to someone that I don't know? But invariably, they'll at least owe a duty to the platform operator. And the platform operator itself probably owes a fiduciary obligation and maybe an advisor in the mix and so on. So it is quite a pervasive duty and it can apply at multiple levels.
Yeah. We've spoken about MDA providers and advisors. Is the fiduciary duty in respect of an advisor a personal duty, or is it something where you would expect that duty primarily is going to point to the licensee responsible for giving advice, or in fact, does it? You mentioned the example of CBA and Mr. Dugan or Duggan, the branch manager.
Yeah.
I mean, he was the one who caused the problem, but was he let off scot-free? And again, analogously, would an advisor personally be in the clear because they're the AR of a license?
Yeah. So Mr. Dungan was held to be acting in as an agent of the bank, and it was the bank that was held liable for breach of fiduciary duties, not him personally. I don't know whether he got off scot-free. I imagine that he probably didn't.
Yeah.
But from a court perspective, there was no action against him personally. The action was against the bank, and I think there is, I think, a risk of an action being brought personally. But the number one rule in looking to take action against anyone in law is follow the money, right? And so whether a client is inclined to take action against an advisor personally when the licensee is there probably with professional indemnity insurance sitting behind it and so on, I think that the licensee should be thinking about that quite carefully. But I certainly wouldn't go so far as to say that there isn't any sort of individual duty owed.
And again, ASIC might be watching that sort of case pretty carefully, so the penalties might arise, in other ways. Well, you mentioned PI insurance there, Andrew. Is PI likely to cover a licensee who's been found to have breached their fiduciary duties?
Yeah, it's a good question, Toby. I think it depends on the terms of the policy and the circumstances of the breach, right? So very often when we see a breach of fiduciary duties, it's likely to fall somewhat into the bucket of dishonesty, and generally PI policies will not respond to dishonesty. But in a circumstance where it's a case of negligence or the like, it very much could respond. I think what's really interesting though is that PI policies usually cover for losses suffered by a client. And as I mentioned, fiduciary duties can require disgorgement of profits and things that are obtained that may not be a loss to the client. And usually a PI policy will not respond to that sort of an action. So if you've obtained an unauthorized profit through your position as a fiduciary and there's an action against you to recover that profit and pay that over to the beneficiary, your PI policy won't respond to that. Whereas if you've recommended a related party product and that product is not performed well and it's because of a conflict that you did that, well, the client could recover their loss under Corporations Act means or under a fiduciary means, and probably a PI would respond pretty much the same way in that scenario.
Yeah, one of the points which I think Stephen Hughes made yesterday in the session on PI was that the other risk you've got is that if you've got an excess of, say, $50,000, your insurer might maintain that each duty that you owed was a separate incident. So you wouldn't be going, okay, well, I've got 10 clients, we've had a blow up in this private credit fund we recommended that we were a party to, one excess. Stephen made the point that the insurer would probably be turning around and saying, no, that's 10 separate excesses.
Mm.
So, yes, even if it did cover it, you might well find you had a you were bearing a great deal of the loss organisationally. If there are other questions that are coming from the floor, what about the fiduciary duties that you might owe if the sort of nominal investor is either a company structure or a trust structure or an SMSF structure? I mean, it's clear that you owe a duty to Bob and Thelma as investors. But what if the investing entity is a non-personal investor? Same risk?
Yeah, absolutely. And there's again a range of case law where the fiduciary duties have attached to sophisticated investors or corporations. So the fact that you might be dealing with, say, a university or or a family office, won't get you out of the fact that fiduciary duties can arise. And again, I mentioned the sort of the distinction of retail and wholesale that we rely on so much won't save you in the context of fiduciary obligations.
Now, one of the characteristics of managed accounts is there are typically quite a lot of parties involved. So you get the advisor, the advice giving licensee, either the MDA provider or the responsible entity of an SMA. But typically the portfolio management function is often undertaken by either a related party of the advice business or a third party. So again, if we end up having a breach of a fiduciary obligation by the portfolio manager, do the sorts of issues that you've been talking about of fiduciary obligations kick in here? And again, who to?
I think they very much could. I think, when we think about related party transactions, we're often very much focused on the more statutory regime of conflicts of interest and conflicted remuneration and making sure that our REM structures are appropriate and that clients are consenting to the REM arrangements. And that certainly is probably the risk that should be front of mind. But there is very much the risk that a client could claim a breach of a fiduciary obligation. Now, in a scenario where the client has consented to the fees being paid to the related party and the like, that will all frame the conversation. But as we talked about, fully informed consent. So how clear is the disclosure? How well informed was the consent? Did the client truly understand what they were signing up for? And the courts of equity will be a lot more sympathetic on that, in certain circumstances. So if you're dealing with, more vulnerable customers, for example, then you're at a greater risk than where you've got, sort of more sophisticated customers in that regard.
And one of the sorts of examples of fiduciary duty that are cited, the CBA one you mentioned, the Dukes one you mentioned, these tend to be transactionally, they arise as a result of a transaction and event, the obligations you owed in respect of an event. But of course, advice is an ongoing, advice and the provision of managed accounts generally is an ongoing thing. So can you talk a little about whether a fiduciary duty might arise over time? And I'm thinking about the sort of monitoring of underperformance. I mean, ASIC issued the consultation paper a year or so ago about monitoring of underperformance. Could monitoring of an otherwise, appropriate service give rise to a fiduciary duty?
Absolutely. Oh, let's say, for example, you've been monitoring, you've been keeping an eye on things, and you've known that your related party product is underperforming, but you've tried to sort of give it another year, and over time, the maybe not losses, but the lost opportunity of better profits has been foregone. And so again, the client might argue they've suffered a loss in the sense that, I got 7% return, I could have got 9%. But equity will step in that scenario. So the better course of action for the client vis-a-vis statutory versus fiduciary would be to say, you owed me a fiduciary duty. in determining not to take action to change my investments, you've breached that duty. Now, I talked about the duties being proscriptive, right? So prohibitive. So I don't have a positive obligation to do ongoing monitoring, but I've got that obligation from a statutory perspective, and I've got that from a due care skill perspective as an advisor. So that obligation arises elsewhere. And when I fail in that obligation, and I fail then to act in your interest, I mean, not acting can be acting, right? Like if I know full well that you're in an underperforming product and I'm supposed to be providing advice, I'm already in the position of providing ongoing advice. So it's not an active step to do something. Actually, the advice I'm giving you of stay in the same product is, that's the active step I'm taking. And so a fiduciary duty could be breached just by doing that, for sure.
And that's actually starting to become more and more personal to the advisor, isn't it? Because there may be no breach of the fiduciary duty by the portfolio manager or the MDA provider or whatever. It's
Yeah, that's right. And I think from the licensee or the advisor, the question will be, well, what did you do to make sure that your agents were acting appropriately and fulfilling the fiduciary obligations that you owe as the licensee?
Yeah. Yes. So this is probably, and that of course cuts across every financial product that is in a client's portfolio as a result of advice you've given or in this case not given. Yes.
Yeah, and I'm hopeful that there are no class action firms on the call today, because I've been quite involved with all of the Shield and First Guardian fallout, for example, and it's one thing that I've been interested to note is that the causes of action that have been explored around getting compensation beyond the amounts that have been paid by some of the providers. No one has mentioned this F word, fiduciary, and no one's talked about disgorging profits, but that is something that could happen. If you explore, for example, not pulling out individuals, but individuals that have generated great amounts of fees to, from a lead generator to push clients into a particular product, they actually could be accountable for those fees that they've earned if they still have them, and that could be paid to clients for whom they were acting as a fiduciary.
So look, in the last few minutes as we wrap up, Andrew, if a licensee says, right, this is an obligation that we've got to take seriously, that we have, and therefore we must take it seriously. What would they do to sort of demonstrate that they actually have an awareness and a monitoring process of their fiduciary obligations?
So I think it is about, the processes and steps you take to manage the people that are working under your banner. And so your ongoing monitoring and review, your training of advisors, the policies and procedures that underpin how you operate, things like your APL, which we talked about, all of that feeds into the sort of the web of things that determine whether or not you're actually complying with your duty or not. And we can all be in a situation where we've got a rogue employee or someone that does something inappropriate, and in all fields, even for us as lawyers, we can have lawyers that go off on a frolic and do the wrong thing, and whether or not we'll be held liable depends on our processes and procedures, and whether we've taken reasonable steps around managing that behaviour. But primarily the obligation will sit with the licensee, or in my case, the firm, unless we can prove we've taken all reasonable steps.
Look, Andrew Bradley, thank you very much for your time today. It's been fascinating and insightful, and for some of us, it will have given rise to considerable thumb sucking and head scratching. So look, thank you for joining us. I look forward to you joining us again tomorrow. Let me just share my screen and remind you of the rest of the series. We have a session tomorrow in a more specific area of identifying, managing, avoiding, disclosing conflicts of interest, a related topic to today. And then on Thursday, a more technical session on fee disclosure through MDAs is a significant obligation. It arises at about 4 or 5 different points of the relationship, both from preceding the establishment of an MDA service through the initial disclosure and advice, and then ongoing. And then on Friday, a session on the strategic considerations with Mark Watmore from NMG, the strategic challenges for managed accounts for advisors. So I look forward to you joining us for the rest of the week, and to you joining us at our masterclasses on best practice advice, on responsible managers' obligations, and on risk management frameworks. So thanks for joining us, and we'll look forward to seeing you again tomorrow.